A very good morning to everyone. On behalf of Goa College of Agriculture, I would extend a warm welcome to all our distinguished guests, our faculty members, participants from other institutes, and our fellow students who have gathered here today for a talk on GI tags, patents, and intellectual property rights. I kindly request all the dignitaries to come on the dais. I request Dr. Ujjwala Ji Haldankar ma'am, Mrs. Reena Menezes ma'am, Mr. Deepak Parab sir, and Dr. Suresh Kunkalekar sir to come on the dais. Light and brightness has always been equated with positivity. To start this occasion on an auspicious note, I request our dignitaries to come forward to light the lamp. I now request our Principal Sir, Dr. Suresh Kunkalekar Sir, to welcome Dr. Ujjwala Haldankar ma'am with a bouquet and a present. I now request Dr. Rachna ma'am to welcome Mrs. Reena Menezes ma'am with a bouquet. I now request Vinod Adkari sir to welcome Mr. Deepak Parab sir with a bouquet. I now request Mr. Satish Patil sir to welcome our principal Dr. Suresh Kunkalekar sir with a bouquet. I now invite Mrs. Reena Menezes ma'am, Deputy Director, Samiti, Directorate of Agriculture, to give the welcome address.
Respected dignitaries on the dais, Ma'am Ujjwala Haldankar from Indian Patent Office, Mumbai. Dr. Suresh Kunkalikar, the Principal of the Goa College of Agriculture. Mr. Deepak Parab from Goa Science Council of Science and Technology. Distinguished invitees, students, lecturers, and dear friends. We talk about GI tag, patents and intellectual property rights. Being from the agriculture department, I can think of GI tagging related to things agriculture. We have a lot of local fruits, crops, vegetables, and the products which are locally originated, and the products are also having characteristics of local origin. Goa is blessed with a rich biodiversity. We have popular varieties like Agasai local brinjal, Taligaon brinjal. Then we have chilies, and the most popular product, which I'm sure many of you all will know, is the Goan Kaju Feni. Okay, some of these have got GI tags, and some of them are awaiting GI tags. There are some which have been refused. I'm sure more details of this will be given by our future speakers. But a few things that I would like to tell you all is that we have, for example, the Taligaon brinjal and the Sat Shiranche. Some of them have got GI tags. Even our bananas, Moiriche keli muntat amche olli keli. Okay, so that has also got a GI tag. Then we have our feni, which has got GI tag. Our chilies, Khola chilies, Harmal chilies, which are local. Harmal are very spicy. The Khola chilies are from Kankon. So these have also got GI tags. Now what is GI tagging? More details of it will probably be given to you later, but it is basically local produce which has got exclusive brand protection rights. Okay. Now when a name is given a GI tag, the same name cannot be used by anybody else anywhere in the world. They can produce something similar, but they cannot give that name. And that name gets immense value all over the world. And because of these, for example, our vegetables and fruits that get GI tagged, they get a better price. Because the moment this name, say for example, our Satshiranche Bende, and if it gets GI tagged, then that same name will carry a lot of worth. Okay? So these are things which we have to push forward. We have our Goa College of Agriculture. The principal is very dynamic. There is a lot of plant breeding, genetics happening. There's a lot of research happening here. And they're looking forward to pushing forward the GI tag indication process for a lot of other products in Goa, along with the help of science and technology. So I wish the college all the very best in this. And seeing so many people around, there are a lot of students here, lots of invitees. It's a pleasure to see all of you all here. And I welcome you all further for these talks. Thank you.
Thank you so much, ma'am. To take this program forward, I would like to introduce Mr. Deepak Parab, sir. Sir did his BSc in Agriculture, MSc in Environmental Science postgraduate diploma in rural development, and postgraduate diploma in intellectual property rights. Presently, sir is working as a project scientist and as a nodal officer for State Patent Information Center, DST, Government of India, New Delhi, as a State Nodal Officer for GI, State Coordinator, Children's Science Congress Program of DST, Government of India, New Delhi, and as a Nodal Officer, Swachhata Action Plan Program of MOEF and CC. Sir has also been honored by the state government for his remarkable work in GI by the Governor of Goa, P.S. Sridharan Pillai, sir, in June 2022. I would now like to invite Mr. Deepak Parab, sir, to give the introductory remarks.
Good morning. Respected dignitaries on the days, Dr. Ujjwala Haldankar, who served Indian Patent Office as Assistant Controller of Patent Design and Trademark. We are with us Ma'am Reena Menezes, Deputy Director and Principal of College of Agriculture, Dr. Suresh Kukarkar. I welcome you all, sir. There are some few stakeholders from the GI, represented by their NABARD is there. Then we have also 5 representatives from these organizations who work as supportive for GI. All the faculty members, my colleague, and our dear students. You know, IPR, that is intellectual property rights, different forms: patent, trademark, design, copyright, geographical indication. But when we look towards patent, trademark, design, copyright, this is something which has come from as an intellectual of the human being, which is not seen in case of geographical indication. You cannot say geographical indication for, say, Taluga brinjal, it has been innovated by somebody, or it has come from the intellectual property of a human being. Even then it is included in the IPR. See, just openly if you go, just overall we see, any GI product is, it's not, we cannot relate it with the intellectual property of a human being, but it has. See, for example, Feni, the process of Feni distillation, which has been followed in Goa for generation to generation. We called it Lavani. Now we are using copper or aluminum pipes. But earlier when we used to do it to distillation by Lavani system, where earthen pot is to be used, and someone is to sit there and water that continuously to get the fermentation and distillation of the water vapor to get it condensed into rock. That has not come by overnight. It has adopted by earlier people. They work on it, and then they have finally adopted that system, particular system, which they found suitable at that time. And then from general to general, people followed the same practice. The traditional knowledge associated with that is involved the IPR. And that's why geographical indications everywhere, in case of all agricultural product, see the traditional practice involved. Now we talk about improved technological practice. See, in case of agriculture students who are here today, they have to, themselves they have to fight for this. How the GI product is processed or manufactured, prepared, or you can say GI agriculture produces method of production and the latest technology, how we are using the hybrid seeds and preparing it. So they have to themselves fight with these two processes while learning this GI products, agriculture product, and they will realize the difference of this. See, for Agasam brinjal, you say, this is a brinjal which is very fleshy with few seeds. That farmers who are involved in that, they have conserved the seeds from generation to generation. Father, grandfather, then the present generation is maintaining the conserving the seeds. They are for adopting the specialized technique in that. Because of if any brinjal they kept, they are not ensured that they will have some minimum quantity of seeds because it is very few seeds. So they are identifying the longest flower, either second or third flower, and that fruit they kept. They keep that fruit for seed purpose. So that's why all this traditional practice which has been involved, or the knowledge which is associated with this GI product, considering that it has been turned into the IPR, or say intellectual property right. See, it was earlier in the European countries, France and other European countries, the GI has been given more popularity because the wine and spirit which they used to prepare at that time, even now they are also leading that. 90% they used to, now they are more than 90% of the product, they are labeling it with GI and selling it, exporting it to other countries. And they have initiated this long back in almost in the last quarter of the 20th century, 1980, 1985, 1990. They have created their own laws based on the originality and source. And later in the year 1992, 1993, 1994, or say before it, we have the World Trade Agreement, WTO. Then as part of this agreement, India also signed the TRIPS, that is Trade Related Aspect for IPR. This agreement has been signed by 117 countries. And then, after the signing of this agreement, geographical indication has got statutory recognition in these all countries. The developed countries have moved forward, then developing countries have started this big, in 1991 onwards. And after this agreement, of the signing of this agreement, it got some momentum. In India, we have geographical indication, registration and protection rights, which has been activated in which has been passed in 1999. And India has established its office, Geographical Indication Registry, in 2003. And the first GI filed was Darjeeling tea. It has a more than 150 years tradition of Darjeeling tea. And almost after 1 year, that is 2005, the first GI granted for Darjeeling tea. It took almost 1 year because September it is filed, September 2004, and October 2005 it got GI tag. Now what is GI basically? Since I think you have the third year student over here, they have this course, IPR course. Anybody can tell me what is GI? Yeah? See, technical definition from your side, because see, science student, being science student, you have to learn the technical definition, write it for the exam. It is identification, it is an indication which identifies any good, particular agriculture, manufactured or man-made, which has been originated from a region or a locality within the region, which have the uniqueness, special characteristic, which has been essentially attributed to the geographical indications, geographical condition of the local, that particular area. Now what are the geographical conditions? These geographical conditions is soil, water and climate. Now in case of Goa Mankrath, how Goan climate is going to affect this soil, water and climate? See, in case of Goa Mankrath, flowering takes place in the month of November, December, January, February, these are the cold period. That means a low temperature required for flowering. With the time, temperature goes on increasing from February end, February second fortnight. This helps to growth of the fruit. And when the peak period in the month of April, May, that high humidity, high temperatures support the nutrients formation in that particular mango and its ripening. So even including sugar content. The proper distribution of rainfall during the 4 months support this plantation during the rest of the period. The high soil content of manganese, iron, support along with other nutrients, support these mango fruits having the particular nutrients content. This is how we relate the local temperature with our local product. In case of now we have filed Goa cashew. Goa cashew means kernel, kajugar. In Goa, we are hardly 22,000 tons cashew kernels are produced. And what is the sale of in Goa? It is 5 times, 6 times, 7 times of the Goan produce. From where this all cashew nuts comes? All comes from African countries. During the last 5 decades, Goa cashew has emerged as a Goa cashew, has emerged as a Goa, there is a brand for Goa cashew. In the name of Goa cashew, the cashew, substandard cashew of Africa, has been brought over here in India, either in Goa or in neighboring states, and that has been processed over there and sold in Goa as Goa cashew. In Goa, being the highest living of standard, at least we need 150 rupees per kg, considering the labor shortage. How to tackle with this issue? How we can protect our, conserve interests of the farmers? It's very important because though you are young and being enrolled for agriculture graduates course, our young generation is not getting ready to associate with the agriculture activities. Because everyone knows it. Then in spite of having a good potential market, already established market for cashew, Goa cashew, nobody is there to take up this in a commercial way. So that's why Goa government has filed a GI for Goa cashew, which is going to support the interests of the farmers who are associated with this cashew production. Once we got the GI for Goa cashew, nobody can sell the Goa, other people from the who are bringing the cashew from other countries, like importing and processing and selling in Goa brand, Goa name, they cannot do it. We have to work strict, we have to follow the strict infringement, and that provision is there within the GI Act. Geographical Indication Act 2002, it has the provision to take the infringement actions. On the other side, Agriculture Department, Forest Development Corporation, they are working to enhance the area under agriculture cashew cultivation so that this existing Goa brand cashew market can be trapped. So, as far as GI is concerned, GI, what are the important features of GI, what are the important functions of GI, what are the benefits the producer are getting through the GI. GI provide a legal protection to the producers, farmers, sellers. It boosts exports. Export very important aspect because see, when India signed the World Trade Agreement in 1901 or 2, I don't know exact 92 somewhere. That time, yeah, it is 92, 93. That time hardly 0.6% of the Indian global export market. 0.6, and 99.4% market was outside India. So considering that, since the GI has to provide, GI ensure the standard of the quality, that is also second point. GI, what is GI tag? See, as I told, that is definition I told you. GI tag is a certificate which is given by the central agency called as Geographical Indication Registry, which is located in Chennai. It is one office for the entire country. It gives the certificate issued to the product for its specific or say unique qualities. That means GI has certain standard of product. GI ensures that standard of the product. That means when you produce the GI any product with the GI tag, that means customers can ensure the quality and they can pay the premium price for it. They will ensure the quality. Suppose tomorrow Goa cashew, we got the Goa cashew process started putting the GI tag on their product. People will ensure this is of a Goan product. They will ensure it. What is the difference of Goan in case of Goa cashew? What is the main quality difference of Goa cashew? In Goa, no, we never harvest a cashew apple or cashew nut. Normal practice is we select the fallen cashew apple because we extract the juice for the any purpose. So this is a tradition followed from long back. Those who are involved in the extraction juice of the apple, they select the cashew fallen from the ground of the tree, near the tree or from the tree. That allows the cashew kernel or cashew nuts to grow to its full strength with respect to its protein and other nutrient contents, including sugar. That is the quality of the Goan cashew. That's why it fetched a premium price, and that globally it has been developed its own brand. The African cashew, which they harvest it at any stage, just mature stage, even immature stage, it is not get proper nutrient development in the cashew kernel. That's the difference of Goan cashew and other cashew. Apart from that is soil content and other climatic difference, that is a different part. Very important, though it is also important. Climatical conditions, the geographical conditions, we talk about soil, water and climate, that is also an important aspect. So, this is the second thing that nobody can use, unauthorized use of geographical indication if stopped. That is third important aspect of geographical indication, to give the protection to the producer that nobody, third party can utilize, as ma'am also told this, that nobody can use this. Suppose I have an example, Armal chili. Armal chili, Khola chili, sir, we have limited production, so the price has also gone to 1,000 rupees per kg or 1,200 rupees per kg during last 2 years. So some neighboring Maharashtra people, that is from Satad and other thing, they bring their chilies in Mapsa market and selling as Armal chili. Because Armal chili is getting almost 1,000 rupees per kg price. And Maharashtra chili is sold in Maharashtra at 400 rupees per kg. So they just paying, can come to Mapsa market on Friday and they can sell it as in the name of Armal chili for 1,000 rupees per kg. So this is how, but there are provision in the act that this can be stopped. So that means it can protect the producer rights by stopping the unauthorized use of geographical indication tag. And very important aspect is, fourth point is, in the case of GI, it enhances, since the producer get a premium price with GI tag, it helps to enhance the income of the producers. And that is the main government intention, that doubling the farmers' income. You might have heard that India is saying that doubling the farmers' income. So this is one aspect of giving the GI tag to the agriculture product or to any other product, say handloom, handicraft, and other food items. And when in case of agriculture item, GI is one aspect where it can promote the government's this thing of doubling the farmers' income. So in Goa, as far as Goa is concerned, Department of Science and Technology with Investment is the nodal department, which is working jointly with the Agriculture Department. And there are many stakeholders who are supporting it. We have FIRE with us, we have NABARD is also providing financial support. Then we have Industry Trade Corporation, Industry Trade and Commerce Department is also supporting the financially. So these all departments are working together to get the Goa, GI for the Goa state. So far we have filed 5 GIs already granted. That is Kola chili, Harmal chili. Then we have Mandoli banana. We have Goan khaje. See, Goan khaje is also unique in it. What is the uniqueness of Goan khaje? Anybody tell what is the uniqueness of Goan khaje? See, Goan khaje is a way normally we offer it to God, and we consider it as a prasad of the God. Dietary village for Jatra, and even in case of Catholic family also they are offered for feast. It's a common in Goa and in both the communities. It is prepared from jaggery and besan with teal and ginger. Again here this all fest and this thing Jatras come normally in the period of winter season. Normally in the winter, most of them are winter season. So this besan and jaggery provides more energy to the required energy during this period. Because earlier the people used to work in the field, they used to survive themselves from the cold period. They used to get this additional energy from this jaggery. The teal also provides energy, and teals are very nutritious. And they are making the bones very strong. They are directly also making bones strong. And then ale, ginger, you don't to tell, ginger is the digestive this thing, supportive this thing. So this is all uniqueness. And one more important uniqueness is the salt, Goan salt, which you used to use. It acts as natural preservative. Even today also for many traditional Goan khajekar, they are using Goan salt because it can survive, the khaja can be survive for up to 45 days. The shelf life can be sustained till 45 days. Earlier what used to happen, suppose if anybody not comes for any fest or any jatra festival, then there is a practice of sending it to her place with somebody, because that time there is no travel this thing, buses were not there. People used to come walking to the respective places, say if any girl is given to with a marriage to other village, then she used to come to her parent place for a jatra and this thing. But sometimes it's not possible. Then this prasad is to submit it to her place with somebody when possibility of chances come to send it to somebody. And this time is to get, that's 15 days, 20 days, 30 days. But even after 30 days, this khaja is to maintain the self this thing without any preservative. So that is the uniqueness of the Goan khaja. And for that uniqueness, we got that GI tag. So now we have 5 more which have been examined by the GI registry recently in the 8th December. That is a Goa Manpurat mango. Then we have Agasim brinjal, we have Goa cashew, we have Satchura bheno. Satchura means not only 7 zeros, it is minimum that should be 7 zeros. See, now I see 7 zeros which have been put out there, they got 9, 10. It is because we have what we are even in a standard benchmark, that minimum there has to be 7 zeros, ridges. From 7 it can be 8, 9, 10, 11. There is no limit for this thing, because due to mutations and cross pollination, there's got even one tree sometimes got 10 zero or 9 ridges or 10 ridges. This happens. So we have dot clause, we have utilized in that distinct that it can for the both. Normally we have 9 zero and 9 ridges and 7 ridges, but here we have up minimum 7 ridges and maximum there is no limit, but it may be maximum up to 11 ridges that we have noticed. So then we have these five, these things are already been examined and accepted. Then we have 4 more GI application filed, that is Korgud rice. Then we have Taliga brinjal. Then we have coconut feni. And one more, Manghilar mango, that is Mangilar. And by 31st March, we are going to file additional 5. That is Kunbi sari. Then we have Goa cashew. See, Goa cashew, we have asked for kernel. Now we are going for Goa cashew, nut and apple. See, here out in case of GI, GI like patent and trademark, individual cannot file GI, as I told you, because it is not anybody's individual property. Yet a community has been given the authority to file the GI. It may be in the producer in the form of association. We have to register that group under the Registered Societies Act. And that is the community has the right to file this GI. And GI registry, it has been 2 important aspects they are following. That is, one, they had maintained a register of the geographical indications. They had the specific qualities they maintain. What are the qualities, the unique qualities of the product, and who is the registered proprietor. Registered proprietor is the one who is the applicant. Then applicant may be not an individual, it's a group of association, as I told you. In case of Goa cashew, we have associated with the Goa Cashew Manufacturers Association, one who processes the cashew and sell it. In case of Mankrad mango, we have formed the association that is called as All Goa Mango Growers Association. And same association been associated with the filing for the Bangilar, and also we are putting the application for Musarad mango now, before 31st March. So application will go on. Now we are concentrating more on the product which can be, have the potential to export. Because earlier we had done Khola Mirchi. Khola is a very small village in this thing, Kankona, and there is no scope for its enhance the production. Enhancing production is a very important aspect to brand it as GI, promote it as GI with a GI tag. So considering that we have, government has taken this thing that we must give a boost to first product which can be promoted and which can be exported. See, one more important aspect of the GI is the conservation of traditional and culture. That's what we are doing in terms of Kunbi sari. Kunbi sari was once for the tradition of the Goan Kunbi people. They are weaving for the various occasions. It may be wedding, it may be even for us, what I learned from the people who studied in this Kunbi tradition, that even for somebody, for family get expired in the family, they used to have different sari. They have for work, they used to have different sari. That's wearing pattern also very peculiar, because there should not be any difficulty while doing work. That's why they used to wear in a very unique pattern. You might have seen how people wearing the Kunbi sari. So this tradition is there, this culture is there, handloom culture that government is promoting. Many people are associated with them, with this Kunbi sari reviving process. So now as an agriculture student, I think you have major role to play in the coming days, because without promoting or branding of agriculture GI product, registration will not solve the, only meager obtaining the GI tag will not solve the problem. Promotion is very important aspect, and that you people have to play a major role in coming days after completing your degree courses. And definitely I expect that some of you may come in various forms to play their role in promotion of GI. And getting involved in this, expert in the geographical indication, expert in trademark, expert in patent, by answering the patent agent exams and other getting involved in this process. See, government of India is taking very major steps during last 3-4 years. You might have heard about Make in India, Made in India, then startups. These all schemes are slow. This marching towards the making India global hub, and that will only possible by promoting IPRs, all IPR together, including patent, design, trademark. You might have heard that China is marching ahead, but yeah, it's true, because China has already surpassed the USA for maximum patent filing and getting granted. Since last 2 years, China is marching ahead for maximum patent filing. Earlier USA was there. And India is also doing a lot of changes as far as in the center and their policies and this concern. Huge appointment has been taken in the patent office. Last year also they had a patent agent exam. This year also they are having patent agent exam. A science graduate can answer this exam. Some of you can think of this. This year is already done. Last year is over. So with this, I thank principal for giving me this opportunity, and I hope that my fellow agricos will definitely do the justice by supporting the state government directives in this. Thank you very much. Thank you, sir.
Thank you so much, sir, for that very informative introduction. I would like to take this opportunity to introduce our guest speaker, Dr. Ujjwala Ji Haldankar Madam. She has a tremendous list of experiences and achievements. Ma'am has received her PhD in Life Sciences in the year 2002 from University of Mumbai, India, and she has done her LLB in the year 2008 from the University of Mumbai. She is currently the CEO of Intellect Dossier LLP from November 2022. She has worked as head of office and senior patent attorney at IPR firm D. Penning and Depenning in Mumbai. She has also worked as assistant controller of patent and design, Indian Patent Office, Government of India, Mumbai. She has worked as R&D manager, cell culture and division with High Media Labs Private Limited, Mumbai. She has worked as a postdoctoral fellow on a project named Involvement of Cytoskeleton Proteins in Retroviral Assembly in the Public Health Research Institute, New Jersey, USA. She has worked as a research fellow on CSIR project in the Cancer Research Institute, Tata Memorial Center, Mumbai. She has also worked as a microbiologist with Cipla Limited, Mumbai, and she is a registered patent agent in India. I would now like to invite Madam to give a talk on GI and patent and intellectual property rights.
Thank Dr. Kunkanikar and Professor Atkari for giving me this chance to present before you and inviting me for this lecture. So, topic of my presentation is geographical indications, patents and intellectual property rights. So, intellectual property, it is creation of mind. It can be anything like painting, it can be article, it can be some invention, it can be software. So, intellectual property covers diverse range of products. As it is created by a person, any person creating any property will desire to have rights over it. So, the territorial region is governed by some body always. So, government who is governing that territorial region will give some rights to the person who has created this intellectual property, and this is intellectual property rights. So, intellectual property rights refer to the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. These legal rights confer an exclusive right to the inventor or creator or his assignee to fully utilize his invention, creation for a given period of time. Intellectual property rights. For now, India is being recognized as a good source of manpower. It is recognized as a source of natural resources, but India should be recognized for its knowledge, for its creation, and that change we have to bring in. So, intellectual property rights need to be on agenda for economic development of India, because Indian economy should be a knowledge based economy. India's international competitiveness should be based on the knowledge rather than on the cheap labor and availability of raw material. Legal and administrative regime of IPR bestows confidence to the IP owner and builds his capacities to create the crucial link between research and its economic applications. If the creator of a property, if inventor knows that my rights will be protected, he will be encouraged to do further inventions or further creations. Two major elements, this is very important. Major elements of intellectual property system is first to register and second is to respect. Registering IP rights, that is whatever you create, you should see that those rights are protected, those creations, those inventions are protected. Second thing is respecting others' right. If somebody has registered his rights, maybe over a trademark, maybe over invention, others should not be copying it because it has market, because it has potential, because it is fetching money. Others should not be copying it. Others should respect that it is his property, he should be using it, and if I want to use it, I should be taking consent from the owner of that property, and I shouldn't be just using without his consent. This is respecting the other's right. So, registration of the IPR, the approach should be to create IP rights by registering patents, designs, trademark, copyright, geographical indications. Recognition of one's right for his registered IP. When one comes across the registered IP rights of an individual or legal entity, the IP right should be respected and should not be infringed by imitating or copying. Now, types of intellectual property rights, as Deepak sir have already mentioned, there are various forms of intellectual property. These are patent, designs, trademarks, geographical indications and copyright. Trademark is the most extensively used intellectual property form. We see trademarks all around us: VIP, Lenskart, Titan, Tanishq, Cotton King, Allen Solly. These are all trademarks. Trademark creates recognition of the product in the user's mind. Trademarks are a very important tool for branding. Branding is for creating image in the mind of the consumer. It helps in the business. It increases the potential of the business. That is why trademark and branding are going in hand and are very important tool for commerce. Branding and trademarks key to commercial success. Branding is the process by which the name or the identity of a company, an enterprise, an organization is communicated. Branding allows the company to differentiate its products and services from the competitors by creating a bond with its customers. Trademark. So, trademark can be any name, it can be some picture, it can be some symbol, it can be even some sound, some music. Trademark is an intellectual property that is depicted as a visual symbol, label, sign or design in order to represent a product by a manufacturer. It helps customers to distinguish the products or services of one company from the rest. Trademark can be filed by any person, it can be filed by individual, it can be filed by company. The owner of a trademark may be any entity with an individual, company, partnership or other group of persons. Trademark is of significance in identifying the origin and source in respect to the quality of a product. When we say, okay, soap is from Unilever, toothpaste is from Unilever, we have some trust in those products because of the branding, because of the trademark aspect. Ensures uniform standards in quality. Effectively provides advertisement to the products. Builds goodwill and image for the product. In India, trademark is administered using these two legislations, Trademarks Act 1999 and Trademark Rules 2017. Previous to this, Trademark Act was there, but it was there were major amendments in 1999, and the recent Trademark Act is being recognized at Trademarks Act 1999. These are few of the trademarks which we see around. Bisleri, just simple water, but still it has created such big impact now. Bisleri, Mahendra, then Bajaj, Haldiram. So everything, medicines, vehicles, food, everything can be commercialized, creating brand. Now types of trademark: product mark being used on the product, service mark being used on the services, collective mark. Collective mark is used by group of people. Now the pharmacy or medical shops using green cross, or CA, chartered accountants, they are using logo on their letterhead. So these are collective marks. Certification mark. This indicates some certification, maybe ISO standards or FSSAI mark on food products. So these are certification marks, convey some certification regarding the product. Shape mark. Even shapes can be trademarked, maybe shape of the label, shape of an article. Pattern mark. If the product is having some particular pattern, even that can be trademarked. Sound mark. Even sound can be trademarked. Sound mark is a sound that can be associated with a product or service originating from a certain supplier. We do know one sound mark, everybody must be knowing, IPL tune. So that is trademark tune. Regarding this sound mark, there is one case. One big company of India, they were going to launch one vehicle, one car, and they launched one video on YouTube for the advertisement of that car. That was some 7 to 8 minutes video showing all the features of that car. But in that 7 to 8 minutes video, there was music piece of some 28 seconds. And a New York based company objected to that 28 seconds piece and said that you are infringing a registered trademark tune and you have to pay us compensation. Now they have to pay some like $1,000 as the damages to the company based in New York. Still negotiations are going on, but they will have to pay a huge sum for that. So this is the value of the trademark. This is the value of the rights. Validity of the trademark is for 10 years and it can be renewed further. Cancellation of trademark. Yes, you have to be very vigilant. If your trademark is registered, you have to keep using it. If you do not use your registered trademark for 5 years, other person can file request for cancellation of trademark before trademark registry, and if the trademark is cancelled by the registry, then any other person is free to use that trademark on their product. So, infringement of trademark. If anybody is using registered trademark without the consent of the owner of the trademark, infringement suit can be filed. Now we see about designs. Designs are registered for visual appearance. Visual appearance of any product can be registered under designs, but it does not register any application or any function of that product. The industrial design recognizes the creation, new and original features for new shape, configuration, surface pattern, ornamentations and composition of lines or colors applied to articles which in the finished state appeal to and are judged solely by the eye. Design system focuses on the aesthetic features derived from the visual appearance of an article. It is just visually how the article looks, that is protected by the design. Design legislation, Designs Act 2000, Design Rules 2001. Again, this is enacted in the wake of our obligation under TRIPS. Essentials of design. The mandatory requirement is design should be novel, it should not have been known before the date of filing of the application. Has not been disclosed to the public anywhere prior to the date of filing or priority date, is significantly distinguishable from known designs or combinations thereof, does not comprise or contain scandalous or obscene matter. Term of protection of design is for 10 years and further extendable to 5 years. So, total term for design is only 15 years. These are the few of the designs which are registered with the patent office. First is the bottle of the cap. Second is machine which is producing some plastic sheets. Camera, car. So, what I want to show here is from small things like cap to the big vehicles to the aircraft, everything can be protected under design. Anything, jewelry design or clothings, color fashion, anything can be applied for design. It is visual appearance. Refusal of design can be challenged in High Court. If you have filed the application and if controller of patents is refusing design for registration, you can challenge the order in the court. Cancellation request for registered design can be filed in patent office. If you know that this design, though has been registered, was already known in the public, you have that evidence that it was in the public domain before the date of filing, produce that evidence to the patent office and patent office will conduct proceeding and will cancel the registered design. Infringement suit can be filed in the High Court. If anybody has registered design and if that registered design is being used without the consent of the owner of the design, you can file infringement suit. Now, copyright, we are just going fast through all the types of intellectual property, so that we can take some time for patents and GI. Copyright is a literary work, we can say article, novel or any broadcasting or painting, these kind of creations can be protected by copyright. Copyright is an intellectual property right that law gives to a creator of literary, dramatic, musical and artistic work and a producer of cinematograph films and sound recordings. Legislation for copyright, Copyright Act 1957, Copyright Rules 2013. Term of copyright, copyright really enjoys very nice good term. It is 60 years from the lifespan of the author. So, in the lifespan of the author plus 60 years, that is the term of the copyright. And if there are multiple authors, the term is 60 years post the death of the last author. Broadcast repetition rights valid for 25 years, performer rights for 50 years. Now, we go to geographical indication. Sir has already introduced you to the topic and it was kind of very nice introduction. So, geographical indication, as sir has already conveyed, is very important for a country like India. We have diverse natural resources. India is known as agricultural country. We have distinct products originating from different regions of India. So, we should take advantage of these things and we should protect as many GI as possible. So, what is GI? GI are intellectual property rights that serve to identify that a product with GI originates from a specific geographical area. The first thing is, as the name itself indicates, it recognizes the area from where the product is originating, and further, and it has those particular characteristics which we try to attribute to that product, and has a quality, reputation or other characteristics that are essentially attributable to its geographical origin. So, when we say that the product is originating from that particular region, we are sure that this product will have XYZ characteristics. So, GI can again be a sign, some symbol, or it can be a name. A GI or geographical indication is a name or sign given to certain products that relates that product to a specific geographical location or origins like region, town or country. Using geographical indications may be regarded as a certification that the particular product is produced as per traditional methods, has certain specific qualities or has particular reputation because of its geographical origin. So, GI serves as a kind of certification mark. It certifies that this product is from this region and has some typical characteristics. Geographical indications are typically used for wine and spirit drinks. As sir had pointed out, most of the wines and spirit drinks have been protected by GI tags. Foodstuffs, agricultural products, handicrafts and industrial products. GI tag ensures that none other than those registered as authorized users are allowed to use the popular product name. In order to function as a GI, a sign must identify a product as originating in a given place. So, the concept of authorized user, producers from that region, whoever wants to use GI on their product, they should be listed as authorized user before the GI registry, and this process requires the no objection certificate from the applicant or from the association who has applied for the GI. So, authorized user listing is must only authorized users are allowed to use GI tag on their product, even if the product is of same standard, even if it is originating from the same region. If the person is not authorized user, he cannot use GI tag on his product. Benefits of geographical indications: enhance the reputation of their goods, build consumer confidence. So, it gives confidence to the consumer that the product will have some desired characteristics and is really originating from the region being claimed for that product. Communicate their commitment to social responsibility, support regional economic development, prevent fraudulent uses of IP rights. Now, legislation for geographical indication. The Geographical Indications of Goods Registration and Protection Act 1999 and Rules 2002. So, these are the two legislations which are being used to administer GI in India. Filing of GI application. Individual cannot file GI application. It either has to be association of group of person, or it has to be some company, or it can be some authority filing GI application, and GI application should be supported by the affidavit of interest in producing that particular product. The applicant can be the association of persons or producers or any organization or authority, and should represent the interest of producers of the concerned goods by filing an affidavit how the applicant claims to represent their interest. Now, documents required for GI application: as I said, affidavit showing the interest in production, then details of the special characteristic of the product, service, and how those standards are maintained. What characteristics you are going to register for that particular product, what characteristics you want to maintain for selling that product in the market. Those those characteristics have to be declared with the GI registry. Certified copies of the map of the region to which the GI relates. So, what region you want to take under GI registration? The people from what region can use this GI tag. Details of the inspection structure, if any, to regulate the use of GI in the territory to which it relates. Some kind of inspection must be done regularly to maintain the quality characteristics of the products under GI as well as to prevent unauthorized use of GI. So, how this inspection will be carried out, that scheme you have to declare to the GI registry. Now, how the registration process proceeds. Filing of application, you have to file the application with all the required documents. Preliminary scrutiny and examination. First, there is formal check by the examiner. If there is any discrepancy, it is communicated within a month. You have to satisfy that discrepancy. Then there is technical examination. Technical examination is conducted with the help of the group of experts, and those consultants then discuss and decide whether to accept GI or whether, if they have any objections, objections are communicated to the applicant. Then there is hearing conducted. On hearing, it is decided whether to accept or refuse GI. If GI is accepted, then it is published in the Geographical Indication Journal. On publication, again it is open for opposition for 3 months. If there is no opposition, then it proceeds for registration, certificate is issued and GI can be further registered, renewed for 10 years. It is a 10 years term. First GI registration is valid for 10 years, you can keep renewing it further for next 10 years. Benefits conferred by geographical indication registration: prevents unauthorized use of GI tag on products by others. It helps consumers to get quality products of desired traits and is assured of authenticity. Promotes the economic prosperity of producers of GI tag goods by enhancing their demand in national and international markets. So, if GI is registered, only authorized users from that particular region can use the GI tag on the product. Even if that product is being produced by the others in the same region, they cannot use GI tag, and of course, producers from the different region altogether, they will not be able to use this GI tag. A protected GI does not permit the holder to forbid someone from making a product using the same approaches as those set out in standards of that indication. So, you cannot stop others from manufacturing those kind of products. You cannot tell that, oh, it is our GI, so you do not manufacture the product. Everybody is allowed to produce the product. Everybody is allowed to grow those kind of crops or those kind of agricultural products or some handicraft items. Anybody can produce it. You can't stop production. Only the thing during sale, using GI tag on the product is regulated. Role of GI in rural development. Sir has already pointed out and explained this in good detail. Geographical indications are mostly traditional products produced by rural communities over generations that have gained prominence on the markets of their precise qualities. The recognition and protection of the markets of these products encourage the producers community to maintain the precise qualities of the product on which the reputation is built. Rural development impacts: good supply chain is structured, increased stabilized prices for the GI product. These, as it is a group of people or as it is association which is commercializing the product, or there is some kind of a group decision in regard to the marketing of the product. So, the product prices for the product will also be stabilized, And again, if the product is tagged with GI, it is fetching at least double price in the market. That is how it is contributing to the development in the rural areas. So, distributed through all the levels of the supply chain, thus adding value. Natural resources can be preserved on which the product is based. If there is good demand for the product, then production will have to be increased. For production to be increased, if the product is based on the natural resources, people will be encouraged to preserve those natural resources. Preservation of traditions and traditional expertise, tourism can be boosted. Geographical indications is a means to preserve traditional knowledge and traditional cultural expressions. Geographical indications work as a collective right. It is a collective right, it is not a right of any individual, and therefore, it cannot be transferred, it cannot be licensed like any other form of intellectual property. Geographical rights are non-transferable rights. There is no provision for a right to license or assign, and the product quality place link underlying the protection of a geographical indication prohibits the transfer of the indication to producers outside the demarcated region. Only producers from that geographical region can be authorized users. Producers from other region cannot be authorized users. Geographical indication products tend to generate premium brand price. Pricing like it depends upon the demand in the market, but at least double price the GI tag fetches. They contribute to local employment creation. If the product is in demand, there will have to be increase in the production and it will lead to the job creation. Geographical indication products often have important spin-off effects as tourism will develop, as it is said. If people have tendency to say, okay, I like this product, where it is from, okay, I like to visit that place. Not everybody visits, but at least few of them start visiting the place, and that is how then tourism in that region develops. And further to tourism, then lodging, boarding, then selling souvenirs, these kind of allied businesses are also encouraged. For development of the region, what are the typical characteristics of the products which you can sell in the market, which you can make your advertisement dependent upon, and whether it has potential in internal or external markets. Identify the market, whether it will have any demand in international market, how you can create international market for that particular product. So, first step itself is identifying the market. Strengthen the cohesion of the group of producers and other operators involved who will be the pillars of the geographical indication scheme. So, it is group of people. There has to be very strong cooperation between the people in the group. They should be agreeing upon the pricing, they should be agreeing upon the marketing policies, they should be agreeing upon the how to maintain the qualities for the product, for those processes. So, there has to be good cooperation between the elements of the group for this scheme to be successful. Set up standards or code of practice or regulation of use that includes product's geographical region of production, description of the production and processing methods, description of the factors natural and or human that are present in the region and contribute to the characteristics of the product. Further, again very important thing, authorized user, if anybody from that region wants to get listed as authorized user, then the association should provide assistance for the those producers for listing as authorized user, and as it is a process before the GI registry. If the assistance is provided, producers are boosted or encouraged to list themselves as GI authorized users, and if if a person is listed, he will tend to then put his efforts to increase the value of the product, to market the product, and that is how the entire GI will be put to use in commercial markets. Devise a mechanism to effectively attribute the right to use the indication to any producer and other operator concerned who produces the product within the established boundaries and according to agreed standards. Establishing traceability, verification and control schemes in order to ensure continued quality and compliance with the code of practice or regulations of use. Devising marketing strategies. This is again must. Marketing strategies should be good and strong. Obtaining legal protection for the geographical indication and designing an enforcement strategy. So, obtaining protection is the first step. There has to be further strategy to enforce this GI, that is to restrict or to prohibit the unauthorized use of the registered GI. How the GI will be enforced? A geographical indication right enables those who have the right to use the indication to prevent its use by a third party whose product does not conform to the applicable standards. If anybody from the outside region is using GI, he can be prohibited, he can be stopped from using the GI on his products. Verification and control must take place regularly throughout the lifetime of GI. So, there must be some kind of inspection scheme which will monitor whether the products which are being produced by the authorized user, they are complying to the standards set under the GI. Promoting the geographical indication is a continuing process. A geographical indication scheme must be managed throughout its existence. So, these are a few GIs registered in India. Ujjwala cashew, actually I was wondering why there is no GI for Goa cashew, but sir told that it has been applied, and further even for the apple they are applying for the GI. So, it is nice to know. Vaghya Ghevda from Maharashtra, Wayanad rice from Kerala. So, these three are agricultural produces. Mysore silk from Karnataka, Pipli art from Odisha, and the last one is Kanoji perfume from Uttar Pradesh. So, this Mysore silk and Pipli art, these are handicraft products, and the last one is the manufactured product. So, agricultural products, handicraft products as well as manufactured products, everything can enjoy GI protection. Goods wise breakup in India in the last financial year. Handicraft, for a handicraft items 389 applications filed and registered are 232. Then is the agricultural 252 applications filed, registered 125, then are manufactured products, then foodstuff and natural products. This is state-wise registered GIs. So, Karnataka tops the list. Karnataka is having 42 GI registered, then Uttar Pradesh has 34, Maharashtra, Kerala has 30 each. So, Karnataka is the topper right now for India. Total in last financial year, total GI register are 420, and till today it is 432. Now, GI authorized user. Initially, there was a kind of not much awareness, and GI authorized user applications were not filed. Only after 2009, GI applications, authorized user applications were being filed, and in the last financial year, it is more than 13,500 authorized user applications filed, and more than 7,500 applications have been registered. And now this our Alfonso mango, it has seen more than 1,600 registered users. authorized users. So there is awareness, people are using GI, only I think this awareness is still localized. This awareness is not throughout the India, it is still localized, and we have to aware more and more producers to register themselves as authorized user. If you will see in Europe, there are more than 59,000 GI registered. Germany is in top amongst Europe. Germany has more than 15,000 GI registered. Then is China. China is kind of moving very fast and is on intellectual property rights front. It is on the very fast track in all kinds of intellectual property rights, whether it is patents, trademarks. They have implemented their strategy and their legislation in such a way that they can protect as much as possible and then don't allow to protect others in their country. So, these are the 5 registered GI, as I told, of Goa. But what I have seen, of course, this is the GI registry data. It may not be updated data, and these applications, there can be more authorized user applications. But from registry records, for Feni, there are only 6 authorized users. For Khola chili, 13 authorized users. For banana, 11 authorized users. For Hermal chili, 10 authorized users, and for Goan Khaja, only 10 authorized users. So, unless and until this authorized users number is increased, the product won't see good commerce or won't get projected in different markets. So, geographical indication is integral part of the system for economic development, tool to protect ownership rights on natural resources and manufactured goods of that particular region. If the product being tagged as GI is based on the natural resources in that region, then those natural resources are kind of claimed under that GI product. So, this link helps us to preserve natural resources from that particular region or to claim our right over the natural resources. Registered geographical indication should be put to extensive commercial use by identifying the market, reaching to the market, constantly maintaining the quality and characteristics of the products under GI, and by preventing unauthorized use of GI. So, we hope now that India will file more and more GI, and we will see some sustainable rural development in India. So, now we move on to the patents. I will just have a little water. Patents are for inventions. Patent is an exclusive right granted by the government to the applicant for his disclosed invention of industrial product or process which should be new, non-obvious, useful and patentable as per the patentability criteria laid down by the national law. So, for patent it has to be novel, inventive and industrially applicable. Legislative framework for patents, Patents Act 1970, Patents Rules 2003. Patents actually first patent was granted to Robert D. Penning, the firm which I worked with, now like it is extension of his firm. So, that patent was granted in 1856 and first Patent Act was enacted in 1911 in India. Now, there were further amendments and the law which is being administered today is Patents Act 1970. So, what is patent? Patent is an exclusive right. Patent is not a monopoly right, it is an exclusive right. What does it mean by exclusive right? It excludes others from using the patented invention without the consent of the owner or without the consent of the patentee. So patent is an exclusive right granted by the government to the applicant for his disclosed invention of industrially applicable product or process. Its legal protection which gives an inventor the right to exclude others from commercial use of the patented invention in the country of issuance. Patent is territorial right. If you want protection for your invention in particular country, you have to apply for patent in that country. There is no global patent, there is no international patent, there is international patent application, but there is no international patent. It is a sanctioned exclusive right for a set number of years in exchange for disclosure to the public. Patent rights are valid for 20 years. And after 20 years, it is in public domain for use. Anybody can use the invention after 20 years. Patent rights, important features. Patent is a grant of exclusive right by the government to the patent applicant for his disclosed invention. Patents are granted to the applicant. Applicant becomes patentee, inventors do not become patentee. There is distinction between the applicant and inventors. Applicant is the one who will be enjoying patent rights. Applicant will be the owner of the patent. Patent rights enables the patentee to take legal action against any person who is exploiting the patented invention without consent or license from the patentee. It is granted for a limited period, that is 20 years, can be enforced only in the country where it is granted. The patent right enables the inventor to derive material benefits. Again, the principle behind intellectual property rights is to commercialize. So, even patents sell the product in the market and fetch monetary gains. Limitations to patent rights. If patented invention, why patent rights are given by the government? Not to create monopoly, but it is reward for the disclosure of the invention to the public. Okay, so what government intends behind it is, you should be working that patented invention in India so that there is further development, there is economic development of India. If you are not working the patented invention within the territory of India, third person can apply for compulsory license to the patent office saying that the patentee is not working the invention in India, let me use the invention, I will market, I will commercialize the patented invention. Again, second thing is, if the product of the patented invention, if it is exorbitantly priced, even then third party can say that, okay, I will sell it at lesser price in the market, give me compulsory license. Third condition, if the patented product is being produced by the patentee and being sold in the territory of India, but it is not satisfying the public demand, even in that case, third party, third person can say that demand is not being satisfied, let me produce it and I will also market, give me compulsory license. Since the inception of this act, first only one compulsory license has been granted that is in 2012. Compulsory license was granted for Nixavar, Bayer's drug that is for liver and kidney cancer. Natco Pharma has applied for the compulsory license and the license was granted. However, there was big cry from the international community. There was very harsh reaction from the developed countries. Then further to that, there were some 4-5 applications for compulsory license, but no compulsory license has been granted. So, I do not say that it is wrong that they say that we are kind of researching on it, we are inventing it and you are just copying and saying that now I will be selling at a lesser price. For this Nixavar drug, it was costing 3,200 euros per month for the treatment, that is 2.5 lakh rupees per month for the treatment. And Natco Pharma said, we can produce the drug and we will make the treatment affordable at rupees 8,000. So, there is drastic difference, but it is not that these international companies or these innovative companies, these are getting these blockbuster drugs every now and then. It is not that every alternate day they are coming out with some drug which can fetch such good price. They have to put some 10 to 15 years of research behind it. They have to invest their intellect, they have to put their finances, then manpower. All these things cumulative is the price of the drug. It is not the manufacturing price or manufacturing cost we are paying for the drug, but it is the R&D cost plus manufacturing cost which is being paid for the drugs. So, there has to be some balance between the two, that what our people can afford and how these research companies will also can continue their research, will continue to give us more and more good inventions, that there has to be some balance between these two things. But from this 2012 is the only one case of compulsory license, thereafter no compulsory license has been granted in India. Common misperception, patent inhibit free exchange of information. No, patent does not inhibit free exchange of information, rather patents mandate the disclosure of the invention. Patent is the right given to the inventor as an award for disclosing his invention. So, complete and full disclosure of the invention is mandated by the law. A skilled person should be able to reproduce the invention seeing the specification or seeing the disclosure in the patent specification. The patent law requires disclosure of the structure of the invention, how to make and use it, and the best method of performing the invention. So, it is the section or it is the act itself says that best method of performing invention should be disclosed in the specification. Patent applications are typically published 18 months after filing and thereafter upon grant. So, patent invention or patent application is rather published after 18 months, and then patented invention once it is granted, then also it is published. First is just awareness to the public, somebody saying that this invention is mine and has applied for the patent, and the second publication like awareness to public that this invention is now enjoying the protection. An applicant is free to disclose the invention any time after the application is filed without jeopardizing patentability. So, once you have filed patent application, you are ready to discuss your invention, maybe for the startup, maybe for technology transfer, maybe for other commercialization efforts, but you are safely, you can safely disclose your invention once you have patented the, you have filed patent application. Why invention to be patented? Source of recognition for the inventors. Inventors get recognized for that technology. Yes, this is the invention which has been created by these inventors. Incentive to develop a commercial product. If the product can be sold at good price in the market, everybody, applicant as well as inventors, are going to get monetarily benefited. License to an existing company or startup. Protection against imitators. While dealing with patent filing, generally scientific community tends to publish whatever research they do, whatever findings they have, they tend to publish it in the scientific journal. So, do not publish before you file. File provisional application if not ready with complete specification, if you are not ready with your invention, if you need like little more time to come to the crystallized invention, then yes, you can file provisional specification. Within 12 months you finalize your invention and file complete specification before patent office. Company should ensure security of data software, sign agreement with employee regarding inventions originating in the company. So, these are kind of very typical issues which we have encountered many a times, dispute between the inventor and the applicant. Even premier institutions, I do not want to name, but one of the topmost institution of India, I should say, there was a PhD student and guide, and there was like major dispute. It reached to Prime Minister office, there was FIR filed, police commissioner was involved, and so we have seen such big issues happening out of this inventorship issue. So, there should be concrete agreement between the applicant and the inventors before filing of the patent application. Non-disclosure agreement, wherever invention disclosure is required before filing of patent application. No objection in law for R&D and experimental work using patented invention. This is again very important aspect, that patented invention is free to be used for R&D purpose. You do not need consent of the patentee for using the invention for R&D purposes. You need consent of the patentee to sell the product in the market to earn benefit out of it. But for R&D purpose, you do not need any consent from the patentee. Conduct novelty or patentability search for invention before applying for patent. So, it is kind of good if you conduct novelty and patentability search, because patent grant of patent is 3 to 6 years process. So, after 6 years if you come to know that yes, my patent is not being granted, I think it is not good, your time, your money, everything is getting wasted then. So, instead while filing the patent application, conduct search and check whether there are any documents around your invention. What can be protected? Only product or process can be patented, use cannot be patented. New use of a known substance, new use of a known process cannot be patented, only new product or new process can be patented. So, patentability criteria: novelty, inventive step, industrial application, and should not fall under the group of inventions that as per section 3 it is shown what inventions are not patentable. So, the invention should not fall under section 3 non-patentable inventions. Now, this novelty and inventive step concepts. Novelty: chair has 4 legs. Now, you have fixed 5th leg to it. Whether it is kind of really required, not required, keep aside. It has 5th leg. It was not existing before. Nobody has seen that the chair having 5 legs. Okay. So, that means the chair is satisfying the criteria of novelty. It is something new. You have created something new which was not existing. Now, comes the inventive step. Whether that 5th leg really has some technological advancement, whether it is really contributing as an invention. But yes, if you say that if a person tilts from side and because of the 5th leg, this chair cannot get tilted for more than 20 degrees. You show that person, there is less possibility that person bending on the side will fall from the chair because of the 5th leg. Then yes, it is inventive, because it is giving some technological advancement to the invention you have created. So, that is how the inventive step criteria is seen by the patent office. Industrial applicability: the invention should be industrially applicable. That means it should be capable of either being produced in industry or being used in industry. So, I had refused one patent application for this section. It was the product was requiring human cornea as raw material. So, if the product requires human cornea from eye as a raw material, how he is going to get raw material for manufacturing that product in the industry? So, the invention did not satisfy the criteria of industrial applicability and the patent application was refused. Non-patentable inventions, these are as per section 3 and 4. Section 4 is atomic energy related inventions. If any invention is related to atomic energy, patent office will not take any action on it. Patent office will send the application, entire specification to the Department of Atomic Energy. They will go through the specification and will check whether they have any concerns about that invention. If they give the consent to proceed with the application, then only patent office proceeds with the application. Otherwise, anything related to radiation or anything related to atomic energy is sent to Department of Atomic Energy. And to my observation, nearly 90% of the applications they withhold and only 10% are allowed to proceed. Those which are not inventions we will see now. An invention which is frivolous or which claims anything obviously contrary to well established natural laws, machine functioning without any input, no input given but still getting some output. These kind of inventions not allowed. One man had filed for one patent application. He used to come with a bottle filled with water and say that this water cures the AIDS and cancer. Okay, and how he was, so I said, what is there in that water that it has such good medicinal value? So he was saying that I have to keep this bottle on a table at 4 o'clock in the morning, then some light comes through the roof, divine figures appear through that light and it blesses the water, and then the water becomes magical, it treats cancer and AIDS. Now how to give patent for such inventions? Okay, so these kind of inventions are refused by patent office and not entertained. An invention, the primary and intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal or plant life or health or to the environment. Any device or machine for theft, method of adulteration of food. So these kind of things which are against public interest are not given patent. The mere discovery of scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance is occurring in nature. So whatever is occurring in nature is discovery and not an invention. If you are isolating some plant constituent, say some phytochemical, if you are isolating it from the plant source, then you cannot claim right over it, because that substance was already present in the nature, you are just isolating it, you are just extracting it out. So as it was already present in nature, you cannot claim right over it. Yes, you can claim right for the process of extraction or process of isolation of that plant constituent. Microorganisms occurring in nature, if you are isolating it, you are not inventing it, you are discovering it. But yes, if you work on the microorganism, if you carry out some mutation, if you change the DNA of the microorganism, then yes, you have, there is some human efforts involved, your contribution is there, so you can patent the mutated microorganism. This is again very important section, section 3D. It is the most debated section, I should say, of the patent law, and still India is in the US trade or US Trade Department's list of the countries for the poor enforcement of IP laws because of this section. Section 3D, the mere discovery of a new form of known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for a known substance, or of the mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. So what this section says, if the substance is already existing, unless and until there is enhancement of the known efficacy, if the substance is known, if you are making new form of that substance, then for that new form of the known substance, unless and until there is enhancement of known efficacy, it shouldn't be granted patent. There is one case behind this section. It was Novartis Pharma, and some of you might be knowing, sir might be knowing, it's Gleevec case. So patent application for Gleevec was refused. It was imatinib was the primary molecule of the Gleevec. It was already disclosed in 1993, and further for the new form of imatinib, beta crystalline form, this application was filed, which was refused by patent office. Matter, it was refused in 2006. Matter went till Supreme Court, and Supreme Court finally refused the application. Judgment of around 112 pages have been issued, rather exactly 112 pages have been issued by the Supreme Court in regard to this section. And for the Novartis case, it's a very famous case. Even if you will put Novartis Gleevec, history will appear. So, it is a section 3D case, and from then many of the patent applications are being refused under section 3D. Yes, now even these developed countries are aware how this section 3D has to be overcome. They are providing appropriate data, and some of the applications are being granted now, but most of the applications of the new form of the known entity, of the known substance, are being refused by the patent office. A substance obtained by mere admixture. So, if there is a composition or mixture, it shouldn't be giving a result of its original constituents. That means, if A and B are two components present in the mixture, then A giving its effect and B giving its effect, then it is not patentable subject matter. A plus B should give some third effect. There should be some synergistic activity, there should be some surprising effect, then only the composition is allowed for the patent. Mere arrangement or rearrangement or duplication of known devices, this is from the engineering point of view. If there is just mere arrangement or rearrangement of the known elements, then again it is not patentable. This arrangement should result in some surprising effect, then only it is patentable. A method of agriculture or horticulture, not patentable subject matter. India is known as agricultural country. If we try giving protection to this kind of methods, it will be very difficult for our poor farmers to survive. That is why method of agriculture and horticulture is non-patentable invention. Any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, other treatment of human being. In short, this section says that any treatment to human body or animal, direct treatment to human body or animal, whether it is prophylactic for prevention, whether it is diagnostic, whether it is curative, is not patentable invention. Any part of plants or animals, any part not patentable invention. Microorganisms which are mutated are patentable inventions, but otherwise any plant part, any cell of the plant, any cell of human, not patentable invention. A mathematical or business method or a computer program per se or algorithms. So, this is again a very important section for the electronics or IT field. Softwares are not patentable as per this section, and software has to be with some hardware, and further it should give some technical effect, then only it is patentable, and it becomes very difficult for the companies like Apple and other IT companies to actually protect their software because of this section in India. A literary, dramatic, musical, artistic work, these are all subject matters of copyright and cannot be patented. Mere scheme or rule or method of performing mental act, not patentable invention. Presentation of information, not patentable. Topography of integrated circuits, again can enjoy copyright, not patentable invention. Invention which in effect is traditional knowledge. Traditional knowledge of India is not patentable invention. India has prepared TKDL, Traditional Knowledge Digital Library, wherein all traditional knowledge of India has been documented in the electronic form. This has been shared across the patent offices of the world, and whenever they come across or whenever they have doubt that this can relate to Indian TKDL, they can access that TKDL library and check whether it is disclosed in the TKDL, and accordingly take their decision whether to grant the exclusive right. So, atomic energy I have already explained. Publication versus patent. So, it is again here it is the inventorship issue has been projected, that inventors should be properly recognized in the when we go for some scientific publication, we see that who all have worked for that invention, who all have actually involved in the carrying out the research project. But when you consider the patent, it is not that who all have actually worked on the project, but it is whose concept was it, whose intellectual idea was it. So that is how the scholarly publication and patent differ. Technical parts of a patent. So this is how the patent specification has to be written. Field of invention, background of the invention, summary of the invention, brief description of drawings, detailed description, claims, abstract and drawings. Out of this, only claims enjoy legal protection. Whatever is into claim, that you can enforce. Whatever is disclosed in detailed description, whatever summary of invention, nothing gets protection. Only claims is the part where you get legal protection. Now types of patent applications in India. Ordinary application. Ordinary application is the patent application which has been first filed in India without any priority from any other country. The application first filed in India is the ordinary application. Convention application, there is Paris Convention. 177 countries have signed this convention, and according to this convention you have to give similar rights to the citizens of the other country, whoever are the signatory to this Paris Convention. Whatever rights you are giving to your citizens, you have to give similar rights to the citizens of the other country. So if a person has filed a patent application in US, according to this convention, he can take priority from that application, and within 12 months time he can file convention application in India. That means he is using priority date, and within 12 months he is coming to other country which is member country under the Paris Convention. So this application, this kind of application using priority is called as convention application. PCT international application. This is PCT treaty again, Patent Cooperation Treaty. 157 countries are member to this treaty. So if a person has filed one application in one country and he wants to explore markets in other countries as well, he wants to protect his invention in other countries as well. Each country has its own patent law. Each country is having its own requirements for filing patent application. So it is difficult to protect the priority date, and again to catch hold of the attorney in each country to fulfill the whatever documentary requirements of each country within that certain period. That is why this PCT, Patent Cooperation Treaty, has been made, and according to this treaty you have to file application before the International Bureau, that is in Geneva, Switzerland, and this application will be called as international application. Taking priority from this application, you can go to the member countries within 31 months. So you get 31 months time to check which country is for your interest or where you want to take your business, then to satisfy the criteria of the or the requirements of the documents of that particular country. You get 31 months period. So this is the only application of this PCT international application. Otherwise there is no international patent. It just gives time for filing application to other member countries. PCT national phase application. Now taking priority from this international application, when somebody enters in different country, suppose I have filed international application, then I feel yes, I want to go for Japan, I want to go for China, and I want to go for US. I am filing 3 further applications taking priority from this international application. Now these 3 applications will be called as national phase applications. So applications originating from the international application are called as national phase application. Patent of addition. This is much easier concept than the earlier one. So patent of addition is if you have already filed patent application and further you do some improvement on that invention and you want to protect that improvement as well, then you can file patent of addition. When an applicant feels that he has an invention which is a slight modification over one for which he has already applied for a patent in India, the applicant can go for patent of addition. Patent of addition expires along with the main patent unless it is made independent. So, you are relating your invention to the already filed application. Divisional application. As per the Patents Act, one patent for one invention. Two inventions cannot be claimed in one patent application. You are paying fees to government, you are paying fees for one application, for protecting one invention, and in that one invention you cannot push two inventions. So, this divisional concept, sometimes applicants do not understand that these two inventions will be considered as distinct, and then they file both the inventions into single application. So, when patent office objects that there are two inventions claimed in the single application, the applicant can divide the application. Applicant can file second application which is separate from the first one. He can divide the claims and file separate application, again taking priority from the first one. This is called as divisional application. When an application for patent claims more than one invention, the applicant on his own, even if the application applicant later realizes that he has filed two inventions in a single application, he himself also can divide the application, or he can divide the application on objection by the patent office. When the application for patent claims more than one invention, the applicant on his own request or to meet the official objection raised in this regard by the controller may divide the application and file two or more applications as applicable for each of the inventions. Now, this is the flow of patent application in patent office. First, file patent application. One moment, I will again have little water. Patent application is filed in patent office. It can be filed as provisional specification or complete specification. If you have filed provisional specification, you get 12 months time to file complete specification. Complete specification is published in the public domain, published in the sense only abstract is published in the journal, but yes, you can fetch the entire application seeing that application number. So, after 18 months, patent application is published. It is open for pre-grant opposition. So, any person if feels that this patent should not be granted and I want to oppose this grant of patent or for this invention, he can file opposition to patent office. After publication and request for examination is filed, a patent application is examined, objections are communicated to the applicant, that is first examination report. You have to reply to the first examination report. If these objections are satisfied, controller can grant the application. If not satisfied, he will call for hearing, and hearing is conducted, all technical discussions are done during the hearing, and again the application is decided whether to grant patent or to refuse. Once patent is granted, again it is published in the patent office journal. After publication, it is open for post grant opposition. For 1 year, it is open for post grant opposition. If anybody says, if any company comes up and says, oh, we do have already this product in the market and these people are claiming exclusive right over it, so this patent should be actually refused and shouldn't have been granted. Post grant opposition can be filed, but only for 1 year. After that, if anybody has objection, he has to go to High Court. So, there are now awareness regarding the protection of the inventions. People are filing many pre-grant oppositions, post-grant oppositions, and even infringement suit. The most recent infringement suit which I have handled is of Supreme Industries. They have some plastic tarpaulin sheet which is protected by patent, and it was only 2 months for their expiry of patent. January 2023 was the expiry of patent, but still they initiated the action, and in October 2022 they conducted raid. Even I was involved in the raid. They conducted the raid to the site and they actually sold the industry, sold the material, and still the court case is now going on. Now the patent is expired, the other party will be able to market the product in market without any legal hindrance, but these the other party will have to pay damages to Supreme Industries for using their patented invention during which the patent was valid. So now for patenting, costs associated with obtaining a patent. Obtaining patents can be expensive, especially if protection is desired in many countries and translation of the patent application is required. In Japan, China, if you go, then you have to translate your invention in Japanese, Chinese, and then only file. Translation cost is very huge. They charge per word. A word is charged 3 to 10 rupees per word, that is the translation cost. That is why Indian applicants going to foreign countries where at least English is not the official language becomes really difficult. The initial costs relate to drafting and filing the application. After that, there are costs associated with responding to any objection being raised by the patent office, and there are often additional patent office fees to be paid before a patent is granted. If there is any formal objection, the controller may ask you to file some forms, and then you will have to pay those fees. So patent is as such not kind of very economic way to protect the invention, but if you want to have your rights over the invention, it is the only way. It does incur some cost. Are there any cost after patent has been granted? The only cost is of renewal of patent, but as the years go on, the fees per year for renewal increase. So the renewal cost one has to bear till 20 years. When can I enforce my patent? As I said, patent is published after 18 months, and then the patent is published after the grant of patent. So if somebody is infringing your patent, you can initiate the suit of infringement only after the patent is granted, that is only after the publication of the grant of patent. You can initiate the suit only after publication of the grant of patent, but you can claim the damages from the date of publication of the 18 months publication, that is initial patent application publication date. From that date you can claim damages, but suit will be initiated only after the publication of grant of patent. Enforcement. The grant of a patent allows its owner to exclude others from exploiting the patented invention. This exclusive right of the patent owner has two main applications: protection against infringement and the possibility of assigning or licensing the right in part or in whole. So you can protect your invention, and you can file infringement suits if anybody is using your invention without your consent, and the possibility of assigning or licensing the right. Invention, if you are not able to commercialize by yourself, you can sell your patent, you can license your patent. Sale is called as assignment in legal terms. Legal tools for enforcement: pre-grant opposition, that is first publication, 18 months publication, you can file pre-grant opposition before grant. Post-grant opposition, once patent is granted, you can file post-grant opposition, or otherwise then you can file infringement suit before the High Court. Technology transfer. First, this technology transfer is very important aspect for academic institutions, because they do have kind of plenty of intellectual power, but commercialization machinery is not available for the academic institutions. So they can commercialize their inventions with the help of other companies, other startups. So research and development, invention, evaluation of the invention, whether it can have any commercial potential. Then if it has commercial potential, then IP protection, marketing, licensing, product development, and then commercial benefit. Licensing. Licensing can be of three types: exclusive sole licenses or non-exclusive licenses. Exclusive license, only single person will be the licensee. You can license your invention to a single entity, maybe company or individual, whoever, but only to a single entity you can license your invention, that is exclusive licenses. Sole licenses, here patentee himself retains the rights to use the invention and he gives only one license. So, the one licensee and one patentee, two entities can commercially exploit the invention. Non-exclusive licenses, non-exclusive means the patentee can give as many licenses as he wants. He can give to 4 people, to 5 people, as many licenses as he wants. Infringement, as I said, infringement of a patent occurs when a competitor makes, uses, sells, offers to sell or imports an embodiment of an invention without the permission of the patent owner. Any commercial use of patented invention without the use of the without the consent of the patent owner is infringement. So, remedies, injunction, the infringer will be directed to stop using the invention and the patentee can claim damages. Working with your patent attorney, inform attorney of what you know about the state of the art, what you know about the invention, what are the already published documents. You should disclose these things to your patent attorney, so he can find out a way how to project your invention as new and inventive. What are the differences between your invention and the state of the art? What parts of the structure of the invention can be changed without affecting the way the invention is used? What are the key structural features that produce the result of the invention? So, you should disclose all the technical information you have for your invention to the patent attorney, so that he can draft the application better. So, to summarize now, this para from my article. So, India needs to have strengthened IPR infrastructure, including IPR managers, IPR attorneys and IPR enforcement machinery to handle matters arising out of the grant of patents, to handle international matters and to be at par with the developed countries. The primary objective of a stronger system of patent protection and enforcement is to maximize the competitive gains from additional innovation and technology acquisition over time, with particular emphasis on raising innovative activity by domestic entrepreneurs and enterprises. Upgrading patent protection alone is an insufficient condition to achieve this. Instead, the patent system needs to be strengthened with a comprehensive and coherent set of policy initiatives and optimize the effectiveness of patents. This can be actualized by further structural reform of enterprises, trade and investment liberalization, promotion of financial and innovation systems to commercialize new technologies, expansion of educational opportunities to build human capital for absorbing and developing technologies, and specifying rules for maintaining effective competition in developing country markets. So, in short, we have to have intellectual property rights system. It is seen that the developed countries, whoever have prospered, have very strong intellectual property systems, very strong enforcement of intellectual property system. So, for economic development of any country, intellectual property system is a must, but India is being still developing country, still we are not able to call ourselves as developed country. As we are a developing country, we have kind of poor people, most of our population is being still classified as poor people. It is really sad to say this, but it is the fact. There has to be proper balance between these exclusive rights given for the inventions and the public interest. But we cannot say that we do not want this system. We will have to have this system if we want to see economic development. If we want to develop, if we want to be called as developed country, we will have to have this system, but there has to be balance between the public interest and these exclusive rights, and this has to be kind of monitored or checked by the government, by different policies and legislations, and we should prosper with this system. Thank you.
Thank you so much, ma'am, for enlightening us with so much information about patents. I would now like to invite our dynamic principal, Dr. Suresh Kunkalekar sir, to give the closing remarks of today's program.
I think Madam has given a lot of intellectual information, and then definitely you may be feeling tired now listening to her for about 45 minutes or 1 hour, but I think this is the lifetime understanding for all of you, especially the entrepreneurs. I got one Mr. Karmo here, who is entrepreneur and then the businessman, and then I'll be taking your questions at the end of this session. So to begin with, I'll just take about 2 to 3 minutes. I will sum up with the information that is provided by our Deputy Director of Agriculture, Mrs. Rina Minejis. What she has mentioned is, she said we have got genetic diversity, genetic biodiversity in the state of Goa, and it is right. So I was working for a company called Mycoa, multinational company. So it was located in Aurangabad. But what I was doing is, I was coming all the way, flying from Aurangabad to Mumbai to Goa, just to collect some of the varieties. What are those varieties? Chilies. Do you know that we have got about 4 to 5 chilies? Tarvoti, you know? Gauti chili. Okay. So what is the speciality of these chilies? Because it has got, why I was coming? Because it has got a characteristic like disease resistance. And what I was doing, I was crossing those chilies with inbred lines or the commercial varieties to get a chili product or the varieties or the hybrids or the transgenics free from that particular disease. Okay. So now the thing is, we have got genetic diversity. And why it has happened? These chilies were introduced by Portuguese about 400 to 500 years back. I was moving to the courtyard of the Portuguese houses. You know the Portuguese houses, big houses. I would take round, and then I have discovered about 5 to 6 varieties of chilies. You know only the Tarvoti. Okay, but there are 4 types of Tarvoti chilies in Goa. In addition to that, there are about another 4 to 5 types, round, saucer-like, okay, and then it gives a different taste and then the smell, and then it has got a specific characteristic as far as growth is concerned. I have taken the Tarvotis and then grown in my polyhouses, and then they were growing like a banyan tree. Have you seen small Tarvoti chili growing like that? And then I suggested the government that you should go for commercial exploitation of this type of chilies. Okay, now Madam has mentioned that the GI tag, it starts with the intellectual input, that is intellectual thinking. And what she says is right. And why and how it is right? Because if you have got the genetic diversity in Goa, is it now not our responsibility to maintain it? Now, Sir Parab has mentioned that there is a GI tag for Khaje. So, and then Madam said it is like no intellectual thinking. But I am praising the people who have invented that Khaje. Is it not the discovery? Is it not their intellectual thinking? About, I think this Khaja business is there in Goa since last 200 to 300 years. That's what I believe. Now, if you consider our ancestors, they had the thinking of surviving in the process of that travel from one state to another or from one village to another village, because in the past they would move from one village to another village by just walk. Even during my childhood, I would walk from my village to another village, just crossing the hill. And in that process, I think this khajem business was developed because it supplies the energy, okay, and then it has got the preservative, that is Goan meat, Goan salt, okay. And then we have got different types of varieties, like chili I mentioned, then you know the Satshira Chabene, 7 Regis okra, okay, and then Agasem brinjal. Now let us talk about the science. Okay, I have got 2 points which are scientifically related. One is the location of the particular variety or the product, and another thing is the genetic purity of that product. Now, I will give you the example one by one. How we take the GI tag is considering the location of particular product, maybe the khaje or the mandori kedi or 7 Regis okra, okay, and then Aksem brinjal. Now, what I have discovered or what I have observed in last 5 to 6 years is many farmers from Khanapur area near Belgaum, they are cultivating okra, 7 Regis, and then they come early in the morning at around 5 o'clock in Goa, and then they give it to local ladies. Those ladies sell those as a local bhende. Now, I don't think there may be any genetic disturbance, but my query maybe to madam is, if we are taking the geographical indication tag for the state of Goa and particular person is growing those varieties in Karnataka, the state of Karnataka, in area called Belgaum, then does it warrant for continuation or having that GI tag? Maybe we will be talking about or discussing these aspects immediately after this session. I will just take about 2 to 3 minutes. Okay. Another thing is about the genetic purity. I worked for Mahiko, multinational company, and then we had a project, or we had a IP cell which would take care of the intellectual property rights. Okay. And then we had a PVP, that is Plant Variety Protection Act, under which we were protecting our varieties. Now, how we were protecting our varieties is we would go for genetic identity of that particular variety or the hybrid. How we would do it? We would suppose we wanted to patent or maintain the genetic purity of the brinjal. Okay. Then what we would do is we would sequence the entire genome of that particular variety. If it is okra, or it is another variety, maybe tomato or the brinjal. Now, if you to really want to go for a genetic identity or checking the purity of that particular variety, and then if you want to really protect it scientifically by seeing the genome or checking the mutation that is happening every year, okay, then you have to shelf about 5 to 10 lakh rupees just to get this genome sequenced. Suppose we want to really protect our varieties or have the identity maintained for that GI tag that will be taking for Mandori kedi, okay, 7 Regis okra, maybe the Korngut rice or Aksem brinjal. So, if there are about 5 products, maybe we have to sell about 1 to 2 crore rupees. Now, we have got agriculture department, we have got people from science and technology, we have got agriculture college, we have got advisor like a madam, we have got government. Can all of us come together and then establish a molecular virology lab to support this GI tag system? Otherwise, somebody will cultivate the okra and tomorrow somebody will take our brinjal to maybe Mumbai or the Belgaum, and then he will start cultivating, and then where? We will be losing the GI tag, we will be losing the identity, we will be losing the genetic purity. Again, I am stressing on the genetic purity. What is happening in Kankon area? You know the Kola chili, and then north we have got Hermal chilies. What is happening? So many years back, somebody introduced a variety called Nisha. It is a hybrid of chili. Now what is happening in Kankona? The Nisha chili, that is a hybrid, it is getting crossed with Khola chili, or Khola chili is getting mixed with Nisha variety. And then what is happening at F1 and F2 level? There is a segregation. I had Dr. Prashant Patil 2 years back, genetics and plant breeding assistant professor. We got the chili, Khola chili from Kankona, and we tried to see its genetic purity. So when we went for the selection and growing it, F1 generation or F2 generation, it is a variety, it is not a hybrid, so don't bother about F1 or F2 generation. So what we have done, what we have discovered is there was segregation. It was not true to type of Khola chili. I have not worked on Hermal, but I think same problem will arise in case of Hermal chili. Another example I'll give you about the genetic purity is the brinjal, Agsem brinjal. About 15 years back, what we have done is we have taken these plants of brinjal to Dharwad, because that time we wanted to go for transgenic brinjal, that is BT brinjal. We initiated a project about 20 years back, and then Mahiko was leading in developing the transgenics. So some part of this transgenic was handled in the University of Agriculture Sciences, Dharwad. So what we discovered is when we went for segregation or selection in field condition, we discovered that there are two types of wangi or the agsem, that is long and then round. If it is a genetic purity, it should give either long or round. Now the thing is, because there is some cross pollination, okay, happened in the past, you are not getting the uniformity. And unless you have the uniformity, whether it is round or long, all should be long or all should be round. But it is not happening, it is segregating. Why it is happening? Because Agsem variety or the any brinjal variety has got about 45% of the cross pollination. Okay? That means eventually if we keep on cross breeding, then after about 10 to 15 years, I think we will not have any say in maintaining the GI tag of, if we get for this 7 ridges okra or the Agsem brinjal. So that is my understanding. Okay, so I think many challenges are there for all of us, all the officials, but I think this type of challenges you students should take. Okay. Establish lab, try to understand what is the genetic purity, what is the F1 crossing, or what is the genetic mixing. Unless you develop that type of skill in life and then don't take the challenges, then I don't think we will be really doing justice for the state of Goa in future. We are blessed because we are born in Goa, and then you know the Goa has got unique characteristic as far as flowers are concerned. You know the Zayo, okay, jasmine of Mardol. It gives peculiar smell, and that type of smell you get only in Mardol. If you take the same plants and plant in Pernam, you will not get that type of smell. So what they say, it is the blessing of the Devi Mahalsa, okay. And I am coming from a village called Kunkolem. It is very famous for pineapple, unique taste. I had taken some of the plants from Kunkolem and planted in a sour dam area, but it failed to give that type of taste. That means it is the uniqueness of that particular place. Okay. So now the thing is, if you want to really maintain the smell, aroma of particular flower, okay, and then the vegetable, and then the taste of particular vegetables or the fruit, then I think we should go for genetic or location, genetic purity, that's seeing the mutations, and then protecting it under PVP, that is Plant Variety Protection Act, only by going for complete genome sequencing, which will cost minimum 1 or 2 crore rupees just for sequencing. Okay, I worked in lab costing about 200 crores. I don't say that you have to invest 200 crores, but at least spend about 5 to 10 crores and develop this type of facilities. Unless we do that, I don't think we'll be really doing justice or will be in line with getting or maintaining the GI tag in future. Thank you so much, ma'am. Yes, I think this discussion is open for queries now, or if you have got any questions, please ask. Madam is there. Okay, and then, sir, I think last time you were inquiring about a bebinka. So, madam, he will be asking the question, but I'll just summarize. So, you know this bebinka, you feel that it has come from Portugal. Sir, please ask this question. About bebinka, you had queries. Yes, yes, please, yes. Please introduce yourself. Come, sir, you can come here.
Hello, I am Carmo D'Souza. There was one affidavit filed on bibinka for Goa, but the origin of bibinka comes from Portugal. It has got 7 layers and it is from the 7 states of Portugal. How can we get a GI for Goa? No, bibinka is traditional of Portugal, not of Goa. But it is in other, what you call territories, what Portugal had conquered that time.
Other territories, they are producing,
Yeah, same as 7 layers. But in 7 layers they're producing it. But I think they are filing affidavit and got to produce it in 21 layers.
then we have to actually, then we will have to actually prove that how their claim is wrong. That we will have to show that they are not producing for 21 years and what they are claiming is not right. It is a wrong claim.
Okay.
And other thing is, if even this applies to the okra, sir had mentioned that even Karnataka is producing okra. So in that case, first we can always go for the application for GI. If any other state objects, then he can join. There are several products which have been registered for more than one state. So if you see that yes, even they are kind of authentic producer of that particular product, then they can join and they can rather share the expenses for the application also. Okay. Because GI is also kind of, as sir has said, it needs all DNA sequencing, this, that, XYZ thing, and it's kind of a bit costly affair. So if they want to be part of it, they can be part, provided they are really authentic producer of that kind of product, then they can be part with you. There are rather in state-wise list which I had projected, there are some GI which have been kind of applied by more than one state and have been registered for more than one state.
Okay.
Yeah.
Thank you, sir. Any questions? Any questions? I know you are hungry, but you should be hungry for the knowledge also. Yes, sir.
It was kind of bombarding session for all.
So we have Dr. Gaurish Haldankar here.
Ma'am, my basic question is there. Should I come in front of you?
That's fine.
Okay. During a GI file application, what are the basics? You told one step is the inspection, where they come and check something. So what basically they are looking for technical details?
Inspection is not done by GI registry. Inspection is the scheme you have to submit to GI registry, how you will maintain the quality for that product, how you will be inspecting the different producers, whether they are maintaining the quality of that product. That is your efforts you have to take to maintain the quality. GI registry will not send any inspectors. GI registry will just register the tag And you have to be, prudent, and you have to be very vigilant to see whoever are using the GI tag are giving the product of that particular characteristics of those typical characteristics in the market. And it is not substandard product that association has to monitor. It is not the responsibility of the GI registry.
Then as part of association, what association should consider some analysis?
Yes, see, if you are registering, say, flat, or you are registering land in your name, on stamp paper you make the agreement, but you don't stop there. What you do, you go and register. Why? Because you want protection for your rights. With stamp paper, your sales agreement is entered. You are saying that now this land will be mine, I am giving you consideration price for the land. But still you register, that is enough, actually speaking, that is enough. But still you go and register the agreement, you pay separate registration fees for the agreement. Why? Because you want to have protection for the government for your agreement. It is similar case, this is intellectual property, you have created it, now you want further protection to it, so you are just registering with the government. Government never comes and see, oh, why this land belongs to this PQR person, why you are encroaching the land. Government never comes. If there is encroachment, you can enforce your rights into the court, showing that I have registered agreement for this land. I have registered rights for this land. It is similar case for the intellectual property. You are just registering your rights with some authority. If your rights are infringed, or in the simple language of this land transaction, if your rights are encroached, then you have to approach the courts, you have to go and say that my rights are being kind of hampered and somebody is using my property without my knowledge, without my consent. That time, this registered rights will help you to show the authenticity of your right. That I do really have these rights, I have registered rights. That is what you can say before the authority, before the court. Registry will never come and do any inspection or will ask you to maintain the characteristics. Whatever you have declared, okay, these will be the 4 characteristics for my product. Only those 4 characteristics you can claim for the product with other producers. So whatever is you are applying before the registry or before patent office, only those things are getting protected.
But I think, ma'am, there might be some cases of refusal.
Yes,
so
there
on
are
what basis? Can you give some examples?
Examples as
I think
such,
that has happened, some queries has come in case of Mankurat, Goa Mankurat variety. So maybe what are the basis for refusal? Any other cases you can just quote?
Refusal means mostly they are refused on the characteristics basis only. If these characteristics are shared by the products from the other region, then there is expert panel who is evaluating your application. So this expert panel decides whether when the association is claiming certain properties for that particular product, then whether these properties are just for this product or they shared by any other product. Whether this product is typically from that particular territorial region or it has presence in other territorial regions, other jurisdiction, other states as well. This is what is monitored. Only characteristics and the presence of the product in the or the origination of the product from the other territorial region. These are the 2 criteria which are being seen.
I just give input on Mankura. So,
yeah.
Madam, what is happening in Goa is we have got 5 to 6 types of Mankura. Why it is happening? It is because of the cross pollination, maybe. Maybe in my property also I got Mankura, but it doesn't taste purely like a Mankura. It doesn't have the fleshy type of, it doesn't have the particular flesh and then the taste, but it is like a little fragile type of thing. But the aroma is of Mankura. So I have got the information from other people also. They say that there are about 5 to 6 types of Mankura. Maybe because of this type of characteristic or genetic mix-up, this GI tag business is not happening, looks like.
This will need further evaluation actually. that what that particular product bears the characteristics, and why it is not being seen as distinct from the other 4 varieties. If you are saying there are 5 varieties, then each variety either should be tagged distinctly, or we should see that how these 4 varieties can be covered under single GI tag by considering their common characters. So there can be 2 strategies. It depends upon the product under consideration, and accordingly the attorney helps to devise the strategy for projecting the characteristics of the product. Either it should be made distinct from each other, all 5 products, or all 5 products should be covered by projecting some common characteristics.
I'll just add on this. So that is maybe the genetic mix-up which is happening, because if you see Ratnagiri Alfonso, Alfonso is grown in Ratnagiri. But if you see Alfonso which is grown in Karnataka, which is also known as Badami, so that might be the case which Alfonso has gone to Karnataka and it has got some different characters. So this might be some of the things.
They call it is Karnataka Alfonso.
Badami. Yeah.
Badami.
Yeah, thank you for clarification.
Yes, but I got one query. You have given the information on getting the GI tag for one perfume. Okay, but my query is, can we take the GI tag for the jasmine that is grown in particular area, for example, Mardol area? It has got a unique smell. Okay, and but if you plant the same thing in other villages, it doesn't give that type of smell, you can say. So is it possible to take?
Yes, definitely. You must be knowing GLC, gas chromatography. So from gas chromatography, yes. So we can generate the profile of the whatever aroma it has, whatever fragrance the flower has. We can generate the profile, and we will show that if the same variety is grown in other region, or a similar variety from other region has different profile of the fragrance. If that is shown, then yes, definitely we can have GI tag for the particular variety. We have to provide data.
We were working on this gas chromatography and then advanced system of the multi-top. In the sense, taking into consideration the bands and then the protein, you would get the genetic sequence going reverse.
Right.
So I think with gas chromatography and then the multi-top system, definitely we can take the GI.
Yes, we have to take help of the advancement of science and show how distinct we are than the others.
Okay, only one last question from my side. We have got one variety, one paddy variety from Kanpur region. It is called Bhangar Star. Bhangar is a gold company.
Okay.
So it gives a typical basmati rice smell. Okay, whether we can get GI tag for this variety of paddy.
Yes, you can definitely get GI tag, but not as basmati. You can get, not as basmati. You can create your own GI tags showing how distinct it is and how it is confined to this particular region only. You have to give proper data, that's it. You have to create proper data, you have to present the case properly, and that's it then.
You can maintain that name, Bhangar Star.
Yes. Okay.
Any more questions?
So you said we are having this GI for 7 and people are getting it from Karnataka. So what is
That's what I asked.
and they are getting our focus.
GI tag is taken for particular location. Only 7 villages it should be Goa. If somebody is cultivating Haldankar area in Karnataka, then eventually we will say it is originating from our place, Karnataka. Then how to go about it? That is the reason I said we have to have the genetic identity. No more sequence, that particular variety, and then document it. I think that is the only possible.
Yes,
Because
distinctness.
I worked on genetic mutations and all for about 15 years. I know exactly.
Okay.
So we are trying it for food we know in food genetics is not there. So it is like everything comes from Karnataka now.
There are a few variations we noticed during our initial preparation of the GI application. And what we noticed that this the variation is because of the initially when the people adopted for making this graph, no, they use the different sources for making the graph, not a single common practice which we followed now. And that's why this variation has been come. So we had noticed, what we had done, we had filed a single application for all GI mancur varieties, including the Cardozo mancur, which has been already registered under that plant genome variety. Yeah. That all comes under Goa mancur. They all, whatever the variation is that will come under Goa mancur mango varieties thing.
Okay, all this
Yeah.
Yeah,
Yes.
yeah, yeah.
Regarding Satshura Beno, no, we have mentioned that Satshura Beno and 9, 8 and anything from.
15 is there in Kanpura, sir.
Yeah.
One person showed me the
Yes.
one variety, it has got 21 regions.
Yeah, exactly.
Which is on the Beno.
Exactly. And now, as you suggested regarding Khanapur, no, so see, we have some certain records that it is originated in Goa. We've got some literature record in the history. If they had some record, they have to produce it.
Yeah,
Yeah.
that is what.
If
Let
they are
them
not
take
record,
objection.
if they didn't have
You
record,
file.
that means they are taken from Goa and they are doing this thing.
Yeah.
So that issue we can tackle after, whatever the issues comes after, say, marketing in Goa in the name of Goa, Satshura Beno, that will come after the post-GI activities. For that we have inspection bodies there. We have proposed 7, 8 members inspection body in the GI applications, which include director from FDA, Industry Trade Commerce, then we have 2 people from the association side, president and secretary, then we have Department of Science and Technology, director of agriculture. These are the committee members are there. They have to meet once in 6 months. And as per the authorized user recommendation, they have to interact with the authorized users, say anything they notice in the market regarding the infringement of false usage of GI. Based on that, this committee will put up the this thing to government. And there, where, see, I didn't mention about regarding authorized user. Actually, what happened now? See, GI tag is given to the association, not to the individual. But association not producing any GI product. Individual farmers, individual members of that association, they are producing the GI product. It may be in case of agriculture or GI, or it may be in terms of handloom or anything, food item also. So, to use the GI tag, it is necessary that they should register with the GI registered authorized user. And they have, once they register, they can use the GI tag, they can sell that product, they can export that product with the GI logo, with that authorized user number. They got a unique authorized user number they get from GI registry. And suppose they notice, if they notice any infringement of this thing, then they can complain they have the authority to complain to the police. They can go to the district court for protect their distinct rights. Or they can intimate registered proprietor, that is the association, and association also can file the case to the district court.
No more queries, no more questions. You have
Is it going to have any GI tag?
Yeah, I think we are closing the session now. She'll be giving the somebody will give the vote out time. But to all the students, I'll give one question as a homework. We have got one teacher. You have to identify the name based on the patent he got. So you have to find out what patent he got, okay, and then you have to tell his name, okay. This is the homework for you.
I kindly request Vinod Adkari sir to deliver the vote of thanks.
Good afternoon all. I will not take more than 5 minutes to propose the vote of thanks. So it has been such an honor to be part of this wonderful lecture by Ujjwala ma'am on geographical indication, GI tags, patents and intellectual property rights. On behalf of Goa College of Agriculture, Old Goa and Sameti, I would like to extend my heartfelt gratitude to our esteemed guest speaker, Dr. Ujjwala ma'am, ex-assistant controller of patents, Government of India. She is coming from Mumbai to deliver lecture here in Goa in her busy schedule. Ma'am covers all the aspects of intellectual property rights like trademarks, copyrights, designs, patents, and most importantly GI, that is GI tags. With respect to Goa, I am confident that this lecture will be largely benefit to our important stakeholders, that is our students and our farmers, by promoting agricultural GI products throughout the world to get more returns to their produce by protecting their intellectual property. Also, her lecture is beneficial to our faculties to write their patents and protect their intellectual property. Also, it will be helpful for technology transfer in the agricultural domain and to develop their academic career. We are thankful to Ms. Reena Meniz ma'am, Deputy Director Samiti, for attending the lecture and giving us permission and also funding support to organize this lecture. We are also thankful to Deepak Parab sir, State Nodal Officer for GI, for gracing the function and in detail valuable guidance to all of us on various Goan GI products like Goan Khaje, Goan Cashew, Goan Cashew Feni, Goan Mankurat Bango and so on. Our sincere thanks to our principal sir, Dr. Suresh Kunkalikar sir, for motivating us to organize this lecture. Also, we are thankful to Director and Assistant Director of GPART for allowing us to use their facilities and to conduct this lecture here in their premises. From Goa, many GIs are possible, maybe around 100 GIs are possible. Definitely, we will also focus on to increase the more number of registered or authorized user as Madam showed the live data in their presentation. Thanks all the teaching and non-teaching staff of the college, all the students of the college for helping us to organize this lecture. Thanks to all the participants from different institutes like NABARD, FIRE and different colleges for attending these institutes, attending this lecture. We are thankful to all the final year students, Exponential Learning Module students and their in charge for serving the refreshment. Participants who registered through Google form, they are requested to sign their attendance sheet, so we will share the e-certificates on their email IDs. Those are not able to attend the event is streamed online and it is recorded on our channel. They can watch later on also. Finally, I would like to thank all of you present here for making the time to be with us today and helping us to make this event grand success. Thank you one and all. Jai Hind.